Item number 1.
My lord, in item number 1, I beg to appear for the Appellant Union of India. I apologize, my lord, at the outset because I'm constrained to appear online because of a medical emergency. My lord,
Yes.
in item number 1, there is a delay of 56 days, my lord. The delay I have explained, my lord, in the application. In paragraphs, the delay is of 56 days have been explained, my lord, in paragraph 7 to 10, my lord. My lord of the, my lord, I apologize, my lord. Paragraph 7 to 12, my lord, I have explained the delay, my lord.
Which can?
My lord, this is can 2 key. One is application for stay and another is application for condonation of delay, my lord.
Yes.
This is can 1, my lord. Because of administrative reasons, my lord, it could not be filed in time. And that I have explained, my lord, in paragraph 7 to 12.
Yes. Who is for the respondent?
I have served upon the respondent and the copy of and affidavit of service is also ready, my lord. My learned junior is there, my lord, if your lordship accommodates, my lord. I tried to serve upon the learned advocate who was appearing before the learned single judge, my honorable single judge, my lord. But my learned friend, senior friend, refused to accept. So I had to serve it upon the parties, my lord.
Return. Return to sender. That it is served. It is not served.
It shows, my lord, item delivered, my lord. At page 7, it shows item delivered.
Delivered to whom?
Or delivered to Kolkata GPO. But that is the address they have given, my lord. I apologize, my lord. It is my fault. But the address it's given that this address has been given, my lord. I've served upon the respondent to this address, my lord.
Please see page 6 what it says. No such person is available in the address on 23rd.
Please return to sender on
Is
no
returned
such.
there and you are saying it is served.
No, my lord, I apologize. I thought I saw page 7, my lord. So,
Affidavit of service is taken on record. Serve afresh, let's see.
Vice. My lord,
Serve afresh, let us see what happens.
my lord, as your lordship direct.
beg for your forgiveness. I went for a split second outside and missed mentioning one small matter for restoration has been pending since 2024, my lord. Can you kindly accept
Give
the
it.
mention?
Will come.
Grateful,
Next
my
week you list it.
At the cost of admonishment, my lord, I seek leave to file this matter expedition. My lord, there is urgency, my lord. My lord,
Not after the list is called, yes.
item number 2.
My lord, I am appealing on behalf of the appellant, my lord. Your lordship on the last occasion heard the matter and asked to produce the certified standing order. Here is the peculiar case, my lord.
Lordship,
The
Asked to produce,
Lordship,
to certified standing orders of the company. It is a peculiar case, my lord, where learned single judge has asked to reinstate a person who has already been superannuated. Your
Lord-
lordship was asked me what has fallen from your lordship, why you have not complied with the second part of the provision to continue the disciplinary proceeding. I have submitted before your lordship that there is our standing order does not permit to continue the inquiry, continue the disciplinary proceeding even after the superannuation, my lord.
so that is why you have to produce.
Yes, yes,
So you have got it.
yes, yes, got it.
Lordship, Mr. Shobhan Majumdar appearing for the respondent, Lordship. I am bringing short pass over, my lord.
Let's see, give it.
Yes, yes.
Who is respondent number 3 in the writ court? General manager.
General manager.
So what did he find? Was it served on him or not?
My lord, he has already superannuated, my lord, in the month of June 2014, whereas the my lord, learned single judge has passed the order in the month of December 2014.
That you have said, that we remember from the last day. We are asking you, what is the big deal if he had looked into it and found that there was a service, then this issue would be redundant.
Yes.
It is only if he finds that it was not served, the issue would assume any relevance. Did he bother to even check whether it was served on him or not? See, relying upon a part of the judgment to assail it, whether as a state you should be doing this, at least you should have looked. You are a general manager, the court has left it to you, giving you, leaving your superintendence over the officer or whoever he is.
Initially, but subsequent order is, my lord, to reinstate him along with the back wages and also de novo inquiry, ask for de novo inquiry.
Which order is under challenge?
Page 68.
What is the date of the order?
Date of the order is, my lord, 24th December 2014.
Correct. That says that the respondent number 3 will see whether a report was served on the employee who was facing the proceeding or not. If he finds that it was served, nothing is to be done. If he does not find that it is served, then something is to be done. So, taking a leverage from that part that yes, he had already retired, you have challenged the order. Why did you not check whether it was served on him or not?
What your
If it was served, then what is to be?
ends there.
Matter ends there. If it is not served, then only you will be in a difficulty that how can I proceed? Then we can understand that, look, this order we cannot comply with, or whatever stand you may take, we don't know. Another thing is that if the court has directed, you do it because they are not objecting. We don't know. We are not there yet. What we are trying to see is your bona fides. Whether there is a procedural lacuna or not. Who is the respondent number 3? The disciplinary authority? No, perhaps the appellate authority.
General manager, my lord, Eastern Coalfields.
So perhaps the appellate authority.
No, appellate authority is, my lord, Coal India Limited.
So who?
Good. General manager is the.
That's we have understood from reading the order. Rather than sending it to the disciplinary authority, the court has trusted the general manager, appellate authority to see that just look into it whether there is a procedural irregularity or not. If there is none, nothing is to be done. If there is something, then we will see.
Without looking to the same, my lord, they have preferred.
Filed an appeal and it is pending since 10 years.
And
Is
it's
this a desirable litigation?
my lord, it is a change brief and thereafter by.
No, but see, going through the order,
Yes.
in 5 minutes we can understand. Then change brief, you must have seen it at least twice.
Yes.
Why he could not take any action? Unless he is faced with the difficulty on account of retirement of the employee, why should he file this appeal? Otherwise, what is wrong in the order? You tell us.
So far the your lordship knows the B form register is concerned. It's a statutory document as per Mines Act, my lord.
B form.
B form register, my lord. On the last occasion, I also produced it. There, my lord, the concerned workman has indicated that his date of birth is 1954. And so far, if no particular, my lord, date has been mentioned, then it is treated as that half of the year should be 30th June, should be the.
What was the charge this person was facing?
Well, charges, so far the charge is defalcation and criminal proceedings and disciplinary proceedings. And learned judge was asked to follow the Paul Antony's case and consider the same.
But he has not done so. He has said if there is a procedural infirmity, you appellate authority, please examine it. Appellate authority says, I will not examine.
Without examining the same, they have preferred facing the problem
Pointless litigation.
and facing
See, the bona fides could have been certain from his conduct had he looked into it. If he was faced with a circumstance that there is no service, he could have approached the writ court.
Yes, I also asked that review should be the appropriate.
He should have approached the writ court
Because-
that look, we have found this, but how we can proceed?
Because Malad, he has already been
He has retired.
retired. And
For 10 years, this matter is pending. Now, who will bear the consequence if we find that he was not served? If we find that it was served, then even today it will be over. But if we find that it was not served, then who will bear the consequence for this unwanted 10-year pendency? All this is pointless. The basic thing is you are required to see whether it was done or not. If as an appellate authority you find that it was not served, what you will do? Tell us.
then Malad,
Assuming that there is no order for proceeding afresh,
there
then
is
what?
no question of Malad back wages because he did not render any service. And there is no scope for reinstatement also there.
So he has been wrongly kept out, he should stay like that.
No, so for the period he has rendered his service, he is entitled to get
And
the
for the remaining period which he has wrongly been kept out, he should suffer, continue to suffer. This is the law. Rather, not a good situation to be created by a state authority. Such a big organization taking up such a trivial issue, leverage from a very trivial issue, not expected. You find out, ask him to give a report on this point. You please understand what we are trying to say. Yes. Where is he? Where is Mr. Ambo? Ask him.
Saying it another court, Lordship.
Ask him to
Matter
come.
is going on, Lordship.
What was the charge? Defalcation
yes, sir.
against the writ petitioner.
Against the petition. Malad, another thing
And
is
what ultimately happened in the criminal case?
yes,
Because it appears to be a very old issue, of 98 or something.
yes.
And what happened in the criminal trial?
And so for the criminal case is also not. Malad, then we have to file the report, Malad, what happened in the criminal case as well as Malad, the whether they've acted upon on the basis of served upon him or not.
You are for the writ petitioner. What happened in the criminal case against you? See? Before we proceed further, find out. Let him. He retired in which year?
2014.
11 years back. More than 11. Now 12, nearly 12 years.
11 and half years.
Nearly 12 years. More than 11, we say. Please gather that information from your respondent. Who is writ petitioner number? GM is writ petitioner number.
Gave me
No, he is the appellant number. Sorry. Here he is the appellant.
Yes, yes.
Appellant number.
GM. Not here, wala, GM is the pro forma response.
Okay.
Pro forma
Forma
respondent number
respondent.
3. এখানেও হচ্ছে pro forma respondent number. Young manager.
Yes, take down. Direction was
Item number 3. 29 January.
But in this matter, I have been interested with his job through this matter. Lord, Mr. Ganguly was arguing the matter, but Lord, to appear that the paper books are not served. In the meantime, Lord, paper books have been served, but there is some defect in the cause title in the name of the respondents. Lord, you Lord, kindly direct us to correct the defect by the advocate on record, and will kindly fix the matter on the next next Thursday. I will do it, Lord.
Where is the paper book? Let us.
Paper books? The paper books have been submitted. These are the copies. Ashwini? Lord, it was submitted before justice in the office, though. Not in the office. They have also copies, Lord. But your Lordship kindly requisition the paper book from the office, Lord.
একটা পেপার বুক হয়েছে কি?
Let us see the order first. You are the writ petitioner appellant.
Lord, page 160 to 180. Application scheme has been refused. Initially, said that it has been kept in sealed cover, though there was no proceeding. Ultimately, no proceeding was initiated or he was not found guilty. Thereafter, they said that the committee has not approved. There is no hope. The judge also held that you have not completed 8 years, but he has completed 23 years. Overlooked it. The same post, no? तो फालतू है तो देखो ना पेपर बुक कहाँ है दिखाई जाइए उधर पीछे उन्हें दे पता फोन नंबर 1345 आइटम में से आगे जाओ ठाकुर बोलो नंबर दूसरा
এখানে Cool.
Yes, you are here basically for the third writ petition.
Yes.
So let us see why the committee could not look into the suitability, your suitability.
Yes,
What is wrong with the finding of the single judge?
wrong is not first thing is that the scope of the scheme, whether selection committee had any role to do independent anything on the self appraisal scheme.
Let us see.
That is one thing. Not second thing is not the learned trial judge has held that he has not completed eight years. But not in the same post he has been working for 23 years. In 93, not there was a suspension order. No proceeding was initiated. Ultimately, court not.
No, all that we have seen.
Yes, ma'am.
You have joined at a particular post, you were there, some appointment was being done, you said don't make appointment, the court passed an interim order, no appointment was made. That issue became infructuous.
Yes.
Then came the issue of your suspension.
Yes.
By virtue of interim order, you continued to your superannuation, you got all dues. That also became infructuous. Prior to your retirement, you participated in the promotion process.
Not promotion, not upgradation.
Whatever it is, higher scale process. In that process, the result was kept in a sealed cover, subject to result of. Now, finally, the court said, let us see what it is. The committee found you not worthy of the higher scale. So it is only the relief in the third writ petition which is today surviving. First two writ petitions are not surviving. The Honorable Single Judge held that there is no scope for interference with the finding. This is the substance of the order. So just tell us why that finding is wrong of the committee. Yes.
Lord, your lordship, kindly, Lord, grant me on this time, Lord. Next Wednesday, Lord, I have been giving the brief now. Mr. Lord, kindly see the list. After 20 years, what they did in university, after retirement, after Lord disposal of the writ petition. There was no allegation against him. They admitted before the writ court. And Lord, now, Lord, the suspension of everything has gone. Your lordship, kindly see, this 2017, this has been done by the university itself.
This is not before us. We don't want to look into this.
Lord, this has been done. This is fact.
This is not before us and we are not going to look into this.
Yes.
We are going to confine ourselves to the order of the Honorable Single Judge. Please give this back to him.
Yes. Lord, your lordship, kindly then take up the matter on Wednesday. Next Wednesday, I will do it.
Sir, it is a 2015 matter. These old matters, how many times?
Not there. Mr. Ganguly was doing, he suffered from pneumonia and was hospitalized. He said that I am not in a position to attend court now. And that's why, Lord, I have been handed over the bill. Your lordship, kindly next Wednesday, I will clarify the position. Lord, the learned single is totally wrong. I will find. On the scheme itself, it will appear. Just, Lord, last night, Lord, I could go through these papers from Lord,
Take down.
Lord, and Lord, the paper book, your lordship.
Ask them to get the paper. The paper book has the rule and all that. The rule under which the committee was examining the claim, it is part of the paper book.
That's it.
Item number 4.
None appears either on paper.
Item number 5.
See. In that order also, right? On the last occasion also there was. The la- See. Just check, this is not a matter of 2000, this is of which year?
7.
No, dismiss for default. Right?
Item number 6.
Same. The order sheet.
Item number 7.
Same order, same dates.
Item number 8.
There is no.
In
Same. Both are from the same recruitment process.
Item number 10.
Same. Is same. All are from the same recruitment process.
Item number 11.
Same. It is the same thing.
Item number 12.
Yes, same one.
Item number 13.
None appears for the writ petitioner.
Dar. 22. Viraj. 22. Item number 14.
None appears on behalf.
Item number 15.
2007.
Item number 16.
Same one.
Item number 17. What are 17.
Page sir. Another. Yeah.
None appears on behalf of the
Appearing on behalf of petitioner due to the death of advocate on record, I am seeking for 2 weeks time for changing the advocate on record. Okay.
yes, take down. MS.
স্যার আপনি ছিলেন 18-তে?
Item number 19.
These persons are still in service. Will be in service. 33 years. So she will be in service. But there's nobody appeared on the last day also.
One would be given.
Not today. You know what?
Item number 20.
None appears. On behalf of
Came out.
22. 23.
23, Madam, I am opposing this appeal on behalf of the.
My lord, Chandre Alum is appearing for the appellate, my lord. She's on her legs on another court, my lord. I'm paying for a short pass.
Can you see the age of the appeal, my lord? Petitioner is suffering.
Where is the phone?
পেপার বুক দিয়ে জ্ঞানগুলো দেখেন 11496 5864
Lordship, the judgment is at page 137.
You are here. Yes. 136.
Lordship?
No, you are here.
Yes. The judgment is at page 137 of the paper. Lordship, I'm placing it.
Let us read it.
Lord.
We'll go through it.
That's all.
Yes.
Lordship. Lordship 15. Lordship, there has been an attack on the violation of principles of natural justice. The court has said that we have not given him the opportunity. Lordship, I humbly submit that that position is not the correct position, Lordship. If your Lordship comes to page 104 of the paper book, that is where the findings on the inquiry report has been placed. The dissension of the uh, disciplinary authority, that he disagrees, why he has disagreed, and thereafter the inquiry report. Lordship, pages 117.
You must have filed an opposition in the writ court.
Lordship, this is a transferred brief. I really don't find that, Lordship. I mean, whatever. I mean, it's application and it's prepared. Then, Lordship, if your Lordship, will I just inquire from my officers? This was not prepared by me. ছিল opposition? Opposition কোথায়? Judgmental order, opposition নেই? না এমনিতে রিট কোর্টে দেওয়া ছিল? That I'll have to. I have come in at the stage of the paper book, Lordship. So, but he has filed a detailed report. And paragraph 9 of the final order at page 123 deals with the representation of the charged official.
Where is your response to the inquiry report?
Well,
Page 117.
start from page 106.
Page 117.
106.
Huh?
Page 106.
117.
106.
Replace it as well.
Huh?
106.
No, the reply is at 117.
17. 117,
Yes.
Lordship. His reply is at 1117. 120.
And where is the inquiry report?
Lordship, the inquiry report is annexed to, it starts from page 106, Lordship. Lordship, 106 to 116, Lordship. This is the inquiry report dated 25th of November 2005.
Where is the disagreement?
Disagreement, Lordship, is at page 104. Lordship, the supply of findings, Lordship. Paragraph 2, there are two. This is 104, 105 with the disagreement.
So it is your case that there was no provision for differing with the conclusion of the inquiry officer.
No, they can differ, but initially they have to.
No, you come to page 120.
What?
120. Read paragraph 5, what you have stated. And this is the finding of the Honorable Single Judge also. That once presenting officer is appointed, you cannot differ. Once a presenting officer has been appointed, there is nothing in the rule which gives power to the disciplinary authority to differ with the presenting officer, presiding officer. Since such submission in my defense has not been confronted with any specific provision or rule or any steeled provisions law, in the facts and circumstances, the communication cannot survive.
My humble submission, that is contrary.
And
to
this is the ground on which the Honorable Single Judge has set aside.
set
Well,
aside.
the rule says the presenting officer is acting on behalf of the disciplinary authority.
Even if it doesn't say, that is the law. Presenting officer always presents the case on behalf of the department. He is not acting on behalf of
He
the.
says, my lord.
He's not-
He is not acting on behalf of the disciplinary authority.
When he says, my lord, not proved, then the department case is not proved.
So therefore, it is your case is that once a presenting officer is appointed, the disciplinary authority has no jurisdiction to differ. He has to accept the inquiry
But
report.
that has been accepted.
Show us from the CISF rules that there is no scope.
Lordship, Janin. Rule 36.
That has been decided by only now the things remain, my lord. Remove the single judge, my lord. Whether in the manner it has been done, whether it can be done.
No, the
Lord,
honorable single
Supreme
judge
Court-
has, the
Supreme Court
honorable
suffices.
single judge, the honorable single judge has held that once presenting officer is appointed, after view of the presenting officer was considered by the inquiry officer, disciplinary authority cannot disagree. So we want to see where is the provision supporting such a finding. It is nobody's case that you are not provided with the inquiry report. It is nobody's case that you did not reply to the inquiry report. It is not your case that it was not considered. You say it cannot be considered because presenting officer was there. And that is what the honorable single judge has held.
No,
That is what
not
is-
only that, my lord. That is one. That is one.
Show any other finding from the single judge order.
Other consider that.
Show any other
I
finding.
come in. So let me first produce, my lord. What is the-
The authority has to accept the findings of the. It cannot.
Just see the finding, single judge.
I come to 36:16. That what is in the rule.
Showing a book, why are you not looking for the book? You're just sitting there. See which book he is referring to. Just sitting there. Pay attention to what is going on in the court. Don't just sit there. See with me.
Lordship, shall I hand over my copy? I hand over my copy, Lordship.
Just let us see. We need 2 copies. Find it.
When it come to rule 36, 5C.
5C.
5C. May I please, my lord.
That is a very common, it is in every
No,
inquiry.
see, that was in the rule. He has written to the authorities. Your lordship can ignore that. Kindly see on what ground the writ petition was allowed.
Yes, on that ground only.
No,
Please see,
no,
come
no,
to
no.
page,
I can see, come to,
sir, come to page 143 of the brief.
and come to, that was all of the ground, not on that ground.
Come to page 143, sir. There are two findings. One, that second show cause was not given, which is incorrect because you have been given a second show cause.
But kindly come to page 139.
We are not talking about submissions. We are talking about findings. The findings, please come, it starts from page 144. There is a substantial force in the petitioner's case that he could not record a finding of disagreement. On the next page, it says, in this case, the disciplinary authority did not give the petitioner a second show cause notice as well. But this is contrary to the record. You were given you have in fact replied to the second show cause notice.
Right.
So this is not factually sustainable.
Initially, one charge sheet was issued, punishment given.
Whatever it is, that
That
is
was
not
rejected.
that is not the issue in the writ petition. The issue is only after submission of inquiry report.
My lord,
Because you have no grievance with the inquiry report, it was in your favor.
my lord.
The disciplinary authority disagreed. So there are two findings. One is that second show cause not given. Factually, it is unsustainable from the records. The second is page 143. You please see the last paragraph.
If that is counted, lordship, see sub rule 21.
21, 2 and 3.
It's absolutely clear.
We have just seen. Don't worry. 36, 21, 2, 3.
Yes, lord. That has been complied.
Item number.
My lord,
Now, page 144, second paragraph. When acting on the representation of the presenting officer, the inquiry officer concluded the charge against the petitioner was not proved. The disciplinary authority could not take a view different from the presenting officer. What is the basis for such finding? How do you sustain such a finding? On the basis of which rule? That is why we are asking you.
my lord, you also please ignore that. Kindly come to page 139. How, my lord, when there is grave violation of natural justice, my lord, that cannot be cured by any state.
Sir, your only issue is the decision of the disciplinary authority. You are not aggrieved by anything else. Your writ petition is challenging the order of the disciplinary authority only.
And appellate authority also.
Obviously, because appellate authority has sustained the
Right.
finding.
Right.
So prior to disciplinary authority's order, there is no grievance. Why should we look into the past?
No, no, my lord, come to one most, what my most, which influenced the honorable judge, my lord, that you will see your
Page?
page 139,
Yes.
second paragraph. Mr. Mahapatra appearing for the.
Sir, Kunj Bihari Mishra, we have seen.
But this is
This is a settled law with very well settled law.
that is the settled law. These
Correct.
are various judgments by the Honorable Supreme Court.
Various
This is
repeated.
Settled law, my lord. There is grave violation of natural justice, no opportunity of violation.
From the time of ECIL,
My lord,
Karunakar case.
So, my lord, no opportunity of hearing has been given.
No opportunity, you have replied.
My lord,
What do you mean no opportunity has been given?
Before arriving a different finding, my lord, that opportunity. These judgments are yes, my lord.
All right, but that's not the ground. The judge has allowed it on the ground that second show cause was not given, whereas it was given.
So these judgments are regarding, I told this, that
Therefore, we said we are not concerned with the submissions. The findings of the judge are much later. There are only two findings. No submission of second show cause, and that there is no scope to differ with finding of the inquiry officer. Why? Because presenting officer has presented the case. How can you differ? He was your representative. Rather enlightening findings. How can it be, sir? This is a common procedure in every proceeding that inquiry officer submits his report, disciplinary authority applies his mind, he may accept, he may reject. If he rejects, after Kunj Bihari Mishra, it has become mandatory that he has to give an opportunity. Tentative findings have to be communicated. Under the CISF rule, it is not tentative. It is he has to form opinion first and then give you that why I should not accept this. He has gone as per 36, 25, 2 and 25, 3.
81, 2, 3.
He has complied with the procedure exactly as it is stated in the two provisions. You please see 36, 25, 2 and 35, 36,
36,
25, 3.
21, 2 and 3.
21, 2 and 21, 3.
that's all right. That's all right, man. But my lord, here the question is, both authorities inquiry presenting officer as an inquiry was said there is no evidence, not proved. There, my lord, petitioner being penalized to the lowest of his basic pay for his oral life. No increment. Can you see, consider from that point of view. Then what that has to be done? It was the duty of the disciplinary authority to give you an opportunity of hearing before
Hearing.
Yes.
Where is that? Show us.
These judgments?
It says hearing.
Yes, man.
Yes. Let us see.
These judgments, man.
This judgment, sir, you are being proceeded against under a procedure, a statutory rule. That rule has been complied in letter and spirit.
Well, here
You
is-
have not challenged the rule.
well, here is judgment.
You have not challenged the rule. You have never challenged the rule that this rule does not contemplate.
I'm not challenging.
So therefore, they have proceeded as per the rule. Where is the question of giving any hearing? There's no requirement of giving it.
Judgment say, my lord, even if there is no provision in the rule, opportunity of hearing has to be given. Supreme Court says, my lord.
All right. So let's see. Show the judgment.
Judgment, I'm not having judgment because
That is the only thing to be seen.
because my lord, these judgments are recorded here by the honorable judge.
As far as we remember, there is no direction that a hearing has to be given. An opportunity has to be given.
Supreme Court says, man.
So show us.
You might give me 2 days time. Otherwise, I have to bring the judgment Xerox. I have to bring the Xerox.
Yes. Take down. We have heard.
15th January.
Item number 24.
Yes. For 1 month. Every time you write the year instead of 26, you write common mistake which is committed.
Here is the list. Or I've given it. These are all unfortunate widows who are living in a very distant territory of district of Calcutta. With the assistance of one of their group gentlemen, they have come. They have come for the substitution application along with the Section 5 application. All unfortunate widows.
So all this is still pending.
Yes. This is a case on a long history. Starting from this court, went to the SAT. From SAT again came to this court and then went to the Supreme Court. From Supreme Court it came back, then again it went to the SAT. And thereafter the matter is coming here. On the last occasion, your lordship directed me.
Let us first pass order on the can application.
First application for substitution has to be allowed.
We are saying let us first deal with the applications,
Yes.
then we'll hear you on merit.
Yes.
So which is the first application? Can 5. Can 5 is for?
Can 5 is?
Substitution of petition number 17.
Yes.
You have given a list to Mr. Mukherjee.
Given a list, yes.
We will rely on what you say. You please verify if the can is for the, if there is no typographical error, then we can proceed.
And 5 up for petition.
Can 5 ka bar korte hobe?
Yes. Substitution, and the can 15 is for the delay in filing the substitution.
Niche.
So can 15, how much delay? Can you please assist us?
Section 5 application is can.
In can 15, how many days delay, please?
Lordship, I'll just show it. Can 5 is okay.
Can 15, how many days delay?
Yes, can 15. Yes. 3,277.
3,200?
77 days.
3,277 days.
Yes.
All right. And then there is a substitution for petition number 23. That is can number 19.
Can 5, yes. Can 6 which is 19. 6 and 19. 6. Can 6. So what I do? And not give you for Can 19. Can 6. Can 6.
19, how many days?
Can 6. It is delay is
736 days.
Then comes can 7, can 18 for petition number 4.
Which one? 7 days? 7. Yes. Can 7.
18 is how many days? Can 18?
The delay is
2,207 days.
Then comes Can 8. Can 8 has two condonation petitions, 17 and 20.
Can
17 and 20.
8 and 17. Can 8 and 17.
17 and 20. There are two condonation applications.
Can 8. Yes. Can 8 and can 17. 544 days.
And Can 20. 20 is also in connection with Can 8. Yes?
Can 20, yeah?
Can 20.
395 days.
Can 8 pay actually. Can 9.
Then comes Can 9. 9 has 22 and 21. No, 21, 22 and 23.
Can 9 is 25.
21, 22 and 23.
Yes. 22, 21 and 23. Yes.
In 21, how many days?
In 21,
Yes, Mr. Mukherjee.
1,246.
46.
And in 20 and 22?
Yes.
And 23?
Can 23. Can 23. 1370.
1370.
137.
1370.
Then comes Can 25 in 10. No, sir. First we'll take up Can 10. Can 10 has Can 25. Then we'll come to Can 11.
Yes. Can 25 is 1434.
34.
1434.
And Can 24. That is in Can 11. Are we getting the numbers right? 24 in 11.
Can 24, my lord.
24 is Can 11.
269.
269.
269.
And Can 12. 28.
Can 12.
28.
Yes. 1429. এগুলোকে বলেছিল
Then comes 26. Then 26.
26, 3,810 days.
The last one is 27.
Another one.
2,200, 100.
Yes.
2122.
Yes.
122. And Can 28.
28 we have already seen 1429.
It would. 28 pages. Photo.
What is substantially what was the claim in the writ proceeding? Substantially what was the claim in the writ proceeding?
Yes. My lord, all these, my lord, the applicants, my lord, they are unfortunate widows of the persons, those who are getting, my lord, by virtue of an order of the East Honorable Court, who are getting, my lord, some pensionary allowance, subject to the final disposal of this writ application.
So there is an interim order.
Yes. Now, these are the widows, my lord.
Can we see that in
each application, your lordship will kindly see, it has been stated very clearly. In one of the application, I am just showing it. But in paragraph 2, it is said, being a village woman living in an interior village of district of Nadia and a hapless lady without any competent male support, she was not advised as to what effective steps is required to be taken to keep the proceeding to continue till final disposal.
we are not on that. We understand the moment you had said at the very outset that they are widows, and
Yes.
we just want to see what is the claim.
My lord.
The claim, where is that interim order earlier passed?
My lord, that is in the main file.
What is the date?
The main file.
In this proceeding?
That is in the main file. We are getting, my lord, it is that.
1811-14.
That is an admitted position. The interim order is still
No,
there.
we just want to know what is it. By reading that, we can see 1811-14.
Yes. Long before.
1811.
1983.
83. No, this writ is of 2014.
That is the WPS. That is the WPS. That is the WPS.
Of?
Paragraph. Can see. Yes. Oh, that's enough. Hold on. Thank you. Yes, yes. Up to date? Yes. 50.
No, there is no interim order. There was no interim order.
Interim order, but order passed for the order signature in a writ proceedings when Mr. Ali's client was not party. No matter
No, in this batch, in this case, there is no order. But this court earlier has passed an order on 1811-2014 that in case they succeed, the amount which has been recovered will be paid to them back with interest. The recovery was not stayed. You have the order, 1811.
Or at page 15, my lord, of that application. Page 15, your lordship is saying, can 6 perhaps your lordship is saying.
No, we are going through the orders.
Yes.
We are going through the orders in the file, in the main file. On 1811-14.
Paragraph 5. The Honorable Justice C.K. Banerjee was pleased to grant an interim order. Continue till disposal of the rule, with
This can
liberty
cease.
to the respondents to apply for varying or vacating the interim order.
that is a condition a petition before the land signature.
Yeah, that's right. The whole thing is arising out of that.
No, this is arising out of tribunal's order.
Yes.
Not tribunal's order. It is tribunal's order because the tribunal has finally disposed of the app.
Yes,
Against that we have come.
against that you have come.
In the tribunal, my lord, did not make any order.
Did
That
not
is-
pass an interim order.
Yes.
So you are referring to which paragraph?
Tribunal passed. Now, with the above, all the writ petitioners were transferred to the district firm. All the writ petitioners have been enjoying the pay scale of so and so. The petitioners were not parties before the Supreme Court appeals.
But
SB 16.
Now, with respect to my when the writ petition is transferred, when the Administrative Tribunal Act came into force in 1985, then within 2 weeks, they must apply for interim order before the Learned Tribunal.
no.
Transferred.
There is already a finding in this regard. That's why we are repeatedly trying to draw your attention
The final order.
to an order passed by this court in this proceeding. You please see that order that has determined the issue of interim order.
Yes.
18/11/2014 order. Do you have it, Mr. Ali? You have the order, 18/11/14 order.
18/11/14, my lord. It must be there in the file, my lord, but I am just with all these.
No, because the can, we have seen what you are pointing out from the can.
Yes.
All that has been considered earlier in this proceeding.
Yes.
On 18/11/14. Just go through that order.
That order I have to
Yes.
on 18/11/14. Note corner. 18/11.
Kindly see the paragraph 47 of the order of the tribunal order.
No, we'll go. First, we want to deal with the can. We just want to deal with the can application. Therefore, we are saying.
Whether the interim order is continuing or not.
That's why we want, at the time of passing order on the can, we want to clarify this aspect. Therefore, we are asking. If you go through it, then we'll adjourn it for the day. It will come back on Thursday.
On next Thursday.
Yes, next Thursday. To enable the learned senior advocate to
I'm checking up the file.
Yes, you do.
File.
Call the next case.
File.
Item number 27.
This matter,
Give him the file. Give him the file. His. His application.
my lords, in this matter, the appellant number 3 has died, as per my instructions, has died on the previous one.
Who?
The appellant number 3,
There is an appellant.
my lord, the petitioner number 3.
Who is petition number 3? So what do you want?
Rajendra Kahar.
What do you want?
My lord, 1 week's accommodation or any date as per your lordship's convenience for filing of this.
Mr. So-and-so.
Grateful.
Item number 28.
In the matter of the Honorable Court liberty to file the decline rejoinder by a supplementary and I'm giving it the copy to whether that's it.
Yes.
Just now. The order of the
This is just completing the record. There is nothing new. You can proceed. We'll see if there is any such a situation, then we may be required to do. 2016 matter. Which order is under channel? 1085. OA number 1085.
Possible, but I tell you what is the fact. The petitioners are filing numbers who initially appointed in the post of clerk typist following government. Therefore, they were promoted. After promotion, below, they have been demoted. After they promoted, they have been demoted.
From clerk cum typist, they were promoted to which post?
Promoted to typist clerk grade 1. Grade 1, they were promoted. They were working.
They were promoted or they were given a higher scale?
They are promoted.
Promoted.
On promotion.
Yes.
Then subsequently, what happened? Working with reference to another case, they have been demoted. On the gradation list based on which they were promoted, that is not the proper one, because government has thought they are clubbed with another group of. That is the issue around. That was challenged before the tribunal. Tribunal rejected it since already they have been decided.
Since already?
Already in another matter, it has been decided on the quoting the same.
Same issue was decided in another way. So relying on that, the tribunal has disposed of that. There is
that is distinguishable. That is my submission.
all right. Let us see then. Then a very simple thing.
Point next. I am more or less short point is important. If I can distinguish, I have some case. If I cannot, I have no case. And so far as the recovery of parties is concerned, tribunal has confirmed that recovery cannot be done.
You did not challenge the order passed in 1304.
Going on for some time, we are not party.
Therefore, we asked you, you never challenged the order passed in 1304. Then what do you have to say?
My submission, entire approach was
Your promotion from clerk cum typist to grade 1 is based on a gradation list quashed in an OA.
Yeah.
Then
we are independent cadre. That was our
Maybe, but your promotion is based on that gradation list.
We are independent cadre, we had a separate promotional challenge. Based
That
on
is not the point. Your promotion was based on that gradation list, your position in that gradation list. That gradation list is quashed. Who is stopping you from agitating your fresh promotion under a separate? If you say you are separate, you agitate it.
That is completely independent of our right, our
Where is your promotion order?
promotional order here is 1:2.
Now, where is the order cancelling the promotion?
MOA.
8 नंबर या 9 कितना है 9 नंबर है दो कर दिया 8 या और तीसरा दे दीजिए zero Good. Good.
Yes.
Just to page 40 or 50. How the post is clear.
What is your grievance in the OA? Come to the OA first.
Way our grievance that is philosophically just for a page 40.
No, that everything we will see pursuant to the grievance you have raised. We'll not go and look into everything that you say. Your only grievance is that the order has been issued without hearing us and no recovery can be made. That is all.
That's not
Come to your OA. Come to your OA. Come to
our
your OA.
case is that
Please come to your OA. Your client's case is in the OA, not what you say. Page 79. Yes, from the bottom. These are your grounds. Yes, there are 12 grounds.
For that, the purported order dated 20th May, the ground
Yes.
number 4,
Yes,
dated 20th was issued total non-application of mine and the
correct.
on considered irrelevant materials and without considering the relevant material.
Yes.
Therefore, we are subject to lawsuit and sanction. If I can say that it was not, my difference was that a decision taken by the DM. DM took a decision on the basis of judgment of.
Which DM? Which decision?
Reason I have referred to,
Which decision the DM has wrongly taken, according to you?
Decision taken that you are.
Which decision?
I have referred to that order of 350, page 150.
Yes.
That's I have referred to. This is the decision which I was reviewed before the tribunal.
Yes. This is not a decision. This is compliance with the tribunal's order. This is no decision.
Therefore, our position is independent of.
Did you forget about independent, department-wise, appointing authority-wise? Did you get promotion on the basis of combined gradation list or not?
We had a separate list.
Did you get promotion on the basis of combined gradation list?
Basis of a separate list.
No, come to your promotion order.
Lordship, kindly turn to page
Come to your promotion order. Come to page 102.
102.
It is basis of on the basis of the final gradation list.
Yes, final
There is no other gradation list.
Lordship, kindly turn to page 4. That's why I was clarification or there. Lordship, turn to page 40 for it. Just page 40. Page 40. After page 40, I am directed to request you to kindly inform the department the dates of actual filing of the post of filling up of the post of typist clerk, which will belong, Milord, which was created by Department Memo number 87.
That is history, sir.
No.
Come to page 102. That is of 2003. 7 years before you got the promotion.
2009 it has been clarified.
In 2010, you have got the promotion on the basis of a gradation list, which has been cancelled by the tribunal. How the promotion can survive? Tell us only this much.
Our feeder post, promotional post, as per government circular.
That is not relevant today.
And page 2.
The gradation list on the basis of which you got the promotion.
This has been clarified.
Not required to be seen at all. That does not arise for consideration.
Kindly see page 120.
We will not look into irrelevant things. Sorry. All that is irrelevant, sir.
No, not irrelevant, Milord.
You have got promotion on the basis of gradation list. That gradation list is quashed by the tribunal. Whether your promotion can survive or not.
Our question is whether my
That question is not arising here. Sir, we will not go into the history from your appointment. You are trying to take us there.
This is a part of record. I have filed it.
You may file it. We will not consider. We will say that we refuse to consider that. Why should we consider? Why should we consider?
Because of the fact,
Just because you have given your entire service history, we are not required to go into everything.
I am clear. Our feeder post for
There is any dispute that the gradation list has been quashed, then only there is a scope. Otherwise, there is no scope. The gradation list on the basis of which you got promotion is quashed. That order you have not challenged. Where is the question of doing anything?
Our cadre is distinguishable.
Maybe then that gradation list was wrong. Then your promotion was wrong. Then also your promotion was wrong. That is not arising here. You may try hard, but we will not go there. Sorry, we will not look into that. That is irrelevant. All that is irrelevant. That does not arise.
For the part of my
That does not arise.
Just for
that does not arise.
Not just for a while,
We will not go there, sir.
This is a part of a record in the original.
So we will say we refuse to go into those issues. We will record it. That's not relevant. That is not relevant. When you were appointed, what was the earlier decision? You from clerk come typist to clerk grade 1, you were promoted on the basis of a gradation list. That gradation list, there was a dispute whether it is to be prepared department wise or appointing authority wise. Some persons were aggrieved, they approached the tribunal. Tribunal quashed that gradation list. Your promotion falls. Where is the question of looking into whether that gradation list was properly prepared or not? That issue does not arise.
are not submitting. So I say, my lord.
Then why we should look
I
into
say,
it?
my lord, this particular issue has been clarified.
Not relevant.
Clarified, which is a part of my original
Not
application.
relevant.
Clarified.
Not at all relevant.
We had a separate gradation list, that's why we are promoted. And Lordship finds in 2009 also, that's the second.
Not relevant, sir. Not relevant. You have yourself said in the OA that the gradation list on the basis of which you were promoted has been quashed. You have admitted to this. It is a averment in your OA. Just read your OA.
We say.
Please read, sir. You can only argue your client's case. Therefore, we are saying what your client has said. Your submission can't be separate from your client's case. So see your client's case.
I cannot say what
Then-
is not there in the record.
then-
How can I say?
That is an admitted position. Unnecessarily, why should we waste time over this?
Page 120 is Lordship kindly refer it only.
120.
Page 120. So this is a part of that.
So many things are part we are not going to look into.
Just one.
Sorry.
Two pages I want to refer.
Yes.
You can refer it.
Yes. How it is relevant? This is not relevant.
No, I am
This is
just
not
reading.
relevant.
I just my Lordship kindly for my
You
satisfaction.
may, you may read whatever you want.
To this documents record, my
Sorry. Sorry.
Kindly refer to the particular these two documents, which is a part of record. In the original application,
There is nothing in this case, sir. Nothing. It is an admitted position that you were appointed on the basis of that gradation list. Then what is that? There is nothing to be argued. You could have challenged the tribunal's order that how you have quashed it in our absence. That also you have not done. And in the second way, you are saying that it could not be done. How it can be? Cannot be.
we try to distinguish that Punendu
Where is the question of distinguishing? Your gradation list has been quashed. Where is the question of distinguishing? You are beneficiary of that gradation list. Now, can you say that gradation list was wrongly prepared? No. Show from your OA, anywhere you have said. Show that line.
That's why
Please show from your OA.
I want.
Please show from your OA that your promotion was on the basis of a different gradation list. Show us. Admittedly, it is from the same gradation list. In so many words, it is stated. Have a look. Where is the question of going into all this? It is a futile exercise, wasting time. You see your averments, come to your grounds. That has been quashed. It could not have been done. You are not saying that there is a separate gradation list.
Our case is there, we based on object. And by general implications, we have been, our promotion order has been quashed. We presented the DI, taking all the points, but.
Your entire grievance in the OA was primarily that no recovery should be made. We have gone through the entire OA. Your primary concern was that recovery should be not made. You had availed the benefit for 5 years. In the promotion order, there was a condition. You were required to give an undertaking that you will refund the amount. Still, the tribunal said that no recovery will not be made. So you have got primarily what you had come to the tribunal for. How is it relevant whether gradation list was properly prepared? It was required to be prepared in a different way. You are beneficiary of that gradation list. How can you say these things? You cannot. Therefore, we are saying after seeing things, we are making these observations. Not that we have not seen it. See your, come to your way.
Is not that he is implementing the order of the tribunal.
See, that is why the tribunal said there is no scope for natural justice. There is no scope for hearing. The order is in compliance of a tribunal's order. At that stage, they could have challenged the order passed in that case, that why it has been passed behind our back. You have not done so. Why did you not challenge that order? Today you are saying that recovery cannot be made. See your grounds, come to your grounds. 12 grounds you have stated. Mechanical, without hearing, nowhere you have said that our promotion was not based on this gradation list. show us from the OA, you go through it again. Anywhere if you have said that it is on the basis of a different gradation list, then there is a scope. Otherwise, how there is a scope? And what we will look into, that gradation list was wrongly prepared. If what you are saying we accept that the gradation list was wrongly prepared, then how you got the benefit of promotion? In that case also you will not get the promotion.
Only one correct.
7.16 to 7.18.
20,
Huh?
7.20,
7 point?
371.
Again you are on appointing authority wise or program wise. Now come to 7.17. 16 to 18, 7.16 to 18. The district magistrate issued so and so, from where it is evident that the order granting promotion to the applicants with effect from was withdrawn. Now the next paragraph you said the said order was issued in compliance of the order passed in OA. We were not made parties. That is your grievance. Then if you are not made parties, then you are required to challenge that order of OA 1304 up to
19, there
yes.
is no illegality in the order of giving promotion to applicants to the post of and the
Who is alleging illegality? Nobody is alleging illegality.
only minute, what is falling for just for my satisfaction.
Yes.
First, I will take this point, keep it on Sangade.
What now keep it on?
No,
There is nothing to be kept on. Nothing is to be kept on now.
Pass an order that I will just take the permission
Not-
that they had education or another list. I will, then I will bow on.
No, now you can, now we will not allow you. You will have to go by the OA. There is no question of taking any instruction. Now we will not allow you. It is not a something which can be improved endlessly for a decade. We cannot. We'll pass the order after lunch.
This writ petition without certified copy. My lord, the urgency is that, my lord, the petitioner is at a terminal stage. And one person claiming to be his husband, he is changing the nominees in her service book, in his name. My lord, this is the urgency.
Date of the order.
Order is 23rd, 23, 12, 2025. My lord.
My lord, my lord.
Not obliged, my lord. My lord, an early date may kindly be fixed.
File
for
it, file
Tuesday.
it, file it. Yes, call the list.
Lords, kindly
Much
mention this matter, my lord, for inclusion, my lord. This is an appeal. My lord, if I may refer to, there is a contempt proceeding that has been referred to that on the next date rule shall be issued. Although the next date has been given in the month of February, that is why I am not preaching for the date.
Let it come in the list.
Yes, yes, my lord. Let it come in the list then.
Yes.
Deeply obliged, my lord.
On your side matter, item number 1.
Lordship, I beg to appear on behalf of the appellants Eastern Coalfields Limited.
Lord, I appear on behalf of the respondents, writ petitioner.
Lordship, by
The item number 1 and 2 of supplementary list, the order passed honorable single judge relying on Mayabab. This is the parent judgment. All the judgments,
yes,
all the order passed by the following the Mayabab. And Mayabab is appearing in the appeal item number, my lord, 5. So in the monthly list. So my humble submission, my lord, kindly take up first Mayabab. So because of
Lordship, it won't be a difficulty. I mean, this is also very well related, and I can explain my body through this also. The list is followed.
the Mayabab is the main judgment.
My body, there is a cross appeal, and it will get
Yes, yes,
complicated.
cross appeal. Take up first Mayabab.
You were the writ petitioner.
I am the respondent. I was the respondent in that. Eastern
what-
Coalfields Limited.
Yes. Why are you aggrieved by the
Lordship, Lordship, first of all, the delay has been condoned, GA1, GA2. Lordship, I am aggrieved mainly by the fact that by this order, it has been ordered that the monthly monetary cash compensation has to be paid from the date of the death of the employee.
GA1 has been allowed?
Huh? So, Lordship,
When?
GA1 has been allowed by October 31's order. October 31st, there was a condonation of delay application, 2 days.
Where is the order? October 31st?
I have a copy.
October 31st order, where is it? Yes.
May I continue? So, Lordship, delay has been confirmed. Now the stay is GA2. Lordship, I am aggrieved by this order, as in I am praying for stay, mainly on the ground that this is a highly belated writ application. Even the application for MMCC was highly belated, and there are judgments of Supreme Court. There is judgment of Supreme Court which has held that in case of extreme, as the general law is that delay and laches can be a ground for refusal of for refusal of relief. An applicant should approach the court as soon as possible. The delay should be taken into consideration at the point of for dismissing of a writ petition. And Lordship, secondly, the report was not called for in this judgment. There were certain disputed facts which we wanted to produce, but the report was not called for. Lordship, before I assail this judgment, Lordship, if I may just give brief background. Lordship, the subject matter, as I have indicated, is monthly monetary cash compensation. Lordship, this monthly monetary cash compensation is basically a
Your submission has been recorded on your behalf in the judgment.
Which we know, Lordship, that judgment was it was not known to us. We have come to know, but
we are talking about the impugned judgment, sir. The judgment under appeal.
Yes,
you were represented there. There is
Yes,
no prayer for filing any report or anything. You have contested the matter on merits.
Lordship,
And how you can raise such a submission in appeal?
Lordship, the report was not called for, and
What do you mean called for? Did you ask to submit a
yes,
report?
your Lordship,
Where is that recorded in the judgment? You can't say everything in here.
Lordship,
there is no such prayer. You see your submission on your
Lordship,
behalf.
there are controverted facts, and the court should have itself
The court should do everything, and you should sit idle.
No, Your Lordship, obviously
There is nothing in the judgment. No issue of delay has been raised by you. See what your counsel has submitted.
Yes, Your Lordship.
Who had appeared? You had appeared.
No, Your Lordship.
Then how do you know what happened?
But Lordship, the issue of delay has
But
been.
Mr. How are you making such submissions?
Lordship, issue of
You must have read the order before coming to
Yes,
court.
yes,
You
yes,
see what has been stated on your behalf, and you are saying no opportunity was given, no report was allowed to be filed.
Lordship, may
The
kindly
full
see.
submissions.
Lordship, may kindly see page number 90.
What is wrong with the order? Come to that.
Lordship, may kindly see page number 91. It has
Yes.
been recorded there. That there is a correction order.
Yes.
There is a correction order that.
Where is that?
Page number 89, 89 of the stay application.
This is after the report's order.
Yes, there was a correction order where it has been recorded that no report has been called for. Initially, it was recorded in that 17 June order that report has been called for, but thereafter on page number 89, that is June 26th, it has been recorded that report has not been called for.
It doesn't say it was not called for. Don't read something which is not there.
This correction shall be.
What does it say? Does it say not called for?
It says
no report was filed. It says.
report
Does
was
not
filed.
say it was not called for. So
Lordship,
that's what we are
in-
saying.
In every application,
If you have
we
not filed a report, then what is to be done?
In every application, we have. I am sure because all these matters that will come up, they all have disputed matters, and because of this Mayabodi judgment, your Lordship, the Honorable Justice has single bench has passed this order on basis on the Mayabodi judgment, stating that since it has been well established by this Mayabodi judgment and
What
other.
has been held in Mayabodi judgment?
Lordship, in Mayabodi judgment, what was held is that this point that it has relied on certain judgments of this High Court to hold that this aspect of monthly monetary cash compensation is a beneficial legislation, not legislation, is a beneficial scheme, and it should be interpreted in that manner.
Arising out of a
This,
bipartite settlement.
Lordship, it arises out of National Coal Wage Agreement.
That's what we are saying. Agreement must be a bipartite agreement.
Yes, it is a bipartite
between
agreement.
the workmen represented through the unions
Yes, Your
and the
Lordship.
management.
Yes, Your Lordship.
Yes.
And it has been held that since it is a beneficial scheme, it should be granted from the date of death, even if there is no application made to that effect. And it does not matter how much delay you have made in applying or in coming to the writ court, you should, the coal company should give it. Now, Your Lordship, in this case, this has relied on certain judgments of this High Court. Lordship, one of those judgments I would like to place.
That case is also listed today.
Yes, my body is.
You are appearing.
Yes, Your Lordship.
Then let us take up that case. Then that will put to rest everything.
Yes.
If
Six.
on today's list. अच्छा file hai, then we can take it up today. APOT 205.
APOT 205 is our appeal. The cross appeal.
The respondent is here.
Yes, well, I'm the respondent.
So we can take it up.
Yes, my lord.
Yes,
That is
let
why
us.
I filed first prayer. I have filed a cross appeal. Or I have filed a cross appeal also. That is also appearing in item number 6.
Lordship, the impugned order. Supplementary affidavit 6. There is a supplementary affidavit in which we had annexed the impugned order. But your Lordship might find it in the memo of appeal also. May I assist?
Where is the impugned order?
Lordship, it is in a supplementary affidavit which we had filed to the stay application. Page number page 16, 17. Supplementary. We had inadvertently forgot to attach in the stay application the supplementary affidavit.
Now it is there on record.
Yes, indeed. Lordship, Lordship, what happened in this matter is that the employee who is Modi Bodi, he died in the year 2002, 7th of July 2002.
Just give us 5 minutes.
That's right.
Yes.
Yes. Lordship, in this matter also, my submission is that this was allowed on the ground that death does not matter how long it has taken back, since it is a beneficial scheme. As you might have produced, it has relied on certain judgments. Since it is a beneficial scheme, and it has held that it is a beneficial scheme, and the right of an employee, the dependence of an employee accrue as soon as the person dies, and it does not matter how delayed the application has been made, it accrues to them right from the date of the death. There was this issue of interest which they have challenged. It was not granted, and it was granted in they have challenged in the cross appeal. Lordship, I would now rely on another judgment of High Court, which has also held on these similar lines. It has not been stated here, but this judgment of High Court has also proceeded on this same line. It is by Justice Subrata Talukdar and Justice Hiranmaya Bhattacharya division bench judgment, and in that judgment, same line of reasoning, that mere delay does not defeat this application, since MMCC monthly monetary cash compensation is an issue of benefit accruing to the employee. Against the what happened in this case, Lordship, let me just apprise you in that case.
So this judgment is also against you.
It is against me, but it has been, we have appealed against this to the Supreme Court, and the Supreme Court has stayed this judgment and final passed an order also. Because in this case, what happened is that the employee died in the year 1999, and thereafter, after a lapse of 21 years, they made an application. And after lapse of 21 years, they made an application, and that was decided for monthly monetary cash compensation. ECL did not respond to that. Against that, they filed a writ petition before this High Court.
In this case?
Before to that, another case.
In Dukni Bhuiya?
In Dukni Bhuiya. And the court directed ECL to decide on that aspect of compensation. ECL decided on the aspect of compensation and directed that the compensation is to be awarded from the date of
death.
ECL decided that compensation will be awarded from the date of making of application. Against this, they preferred an writ petition to this High Court, and this honorable single judge, it was held that no, it has to be held from the date of death. Against this, this appeal was preferred, and in appeal also this was held that it has to be held from the date of death.
The date of death, that we have seen.
Yes,
the
and thereafter we had appealed to the Supreme Court. The Supreme Court judgment, Lordship may kindly. In the Supreme Court judgment, initially an interim order was passed stating that from the three years prior to the date of filing of the writ petition, it has to be given, and not from the date of death. Thereafter, on 13th October, the final order was passed. It was held that having regard to the fact that the respondent had not applied to the appellant management for seeking monetary compensation upon the demise of her husband who had died in harness on 14 September 1999, till as late as the year 2020, we are of the opinion that the interim order passed by this court on 14th October, directing the appellant to pay to the respondent the amount due under Clause 5 of National Coal Wage Agreement, as amended up to it for the period reckoned backwards for 3 years prior to the date of writ petition.
Yes, we have seen 21 years or later she has filed the writ petition. Therefore, in terms of the interim direction, whatever has been paid is sufficient.
Yes, because it has been held that it is in the peculiar
judgment is of 23.
It is a judgment of 23.
And what is the date of the order passed in the case of Putul by the Apex Court?
That was in the year 2022. 2018.
Where is that order?
Putul Ravidas.
That was also taken to the Supreme Court.
Putul Ravidas was taken to the Supreme Court.
What happened? Where is that judgment?
Lordship, I don't have that order of the Supreme Court in that.
Because the Supreme Court has affirmed that judgment.
It has affirmed, but
and here it says in the peculiar facts of this case. So let us see what is there. This is see the last page.
Yes, indeed, Your Lordship. It
in
does
the
not.
Peculiar facts of this case.
I admit it does not lay any precedent in that
Correct.
of that term. But Your Lordship,
so let us see where Putul judgment is. Any other judgment you want to rely on?
Lordship, I want to actually draw parallels of this.
Any other judgment you want to rely on?
Yes, Your Lordship, because I want to draw parallels with the aspect of compassionate employment, and on the aspect of compassionate employment, it has been held by
No,
this.
in any of these matters, issue of compassionate appointment is there.
Because it is not directly in the issue, but initially they applied for compassionate employment. My Lordship,
See, initially he was appointed is also there. We are not concerned. We are saying the issue arising for consideration in all these matters is MMCC.
MMCC, indeed.
There, it is coupled with their claim for compassionate appointment, which faded because lapse of time.
Yes, Your Lordship.
But the issue surviving is MMCC.
Indeed,
We
Your
are asking you, as a matter of fact, in any of the writ petition, any claim for compassionate appointment is subsisting. All are relating to MMCC.
But I want to draw parallels with compassionate
You
appointment.
may, but we are asking which other judgments you are relying upon.
Lordship,
This is one of the larger bench judgment in our High Court and one of the upheld by Supreme Court. Lord, I have
So how many judgments in total? You must be referring to the same judgments.
My learned friend has now referring, my lord, to 2022 17 Supreme Court. This is not, my lord, I am.
This is for compassionate appointment.
This is not relevant to this, my lord.
He has not given that judgment yet.
This is pertains to compassionate appointment.
Actually, what I am trying
He
to
wants to draw a parallel. He will argue. Why are you?
Actually, because this whole scheme.
How he can draw a parallel from compassionate appointment in MMCC? Is there any scope left after decision in the case of Putul and Sumi for this court to travel beyond those judgments? In Sumi, it has been already decided that compassionate appointment is something else. It is coupled with the concept of immediacy. This is a financial obligation. Whether they get compassionate appointment or not, it is automatically to flow.
In my humble submission,
So if these two judgments are decided by a coordinate bench, how can you now draw a parallel? When it is already rejected by a coordinate bench.
MMCC aspect is also related to survival of the dependents.
Can you argue this when you have not assailed the judgment in Sumi? Have you assailed the judgment in Sumi? Then you are the same employer. You have suffered a judgment on that point. Can you argue it now? And it is a decision of coordinate bench. We cannot travel beyond that.
That I admit.
Then where is the?
I was trying to rely on this Supreme Court judgment of Dugna.
Can you?
On factually, I was trying to draw.
You are trying to rely on this judgment on the principles of law.
Yes.
But with respect to the specific wage agreement, there is a judgment. In Sumi, it has already been held. See the judgment. It has been considered in Bauri's judgment. This very same plea has been rejected.
This wage agreement forms the subject matter of these judgments.
Come to page 22 of your supplementary.
Yes,
The right to compensation is unconditionally and is not dependent on any application.
That is what the high courts have consistently held. But what I was trying to rely on this Supreme Court judgment, I admit it is on the peculiar facts and circumstances. But what my submission is that even this MMCC should also not be stressed to that extent, because everything needs to be proceeded by an application, by making an application. Merely by this is.
Can you, therefore, sir, we are asking you, is it open for the same employer to make such a contention after suffering a judgment by a coordinate bench? If at all that submission was to be made by you, then somewhere else, not here. We are bound by that decision and we don't find any disagreement. It is an agreement. It is under labor laws.
Yes, sir.
These are called bipartite settlement kind of a thing.
Indeed.
It is for the social, it is a social beneficiary initiative to provide social security to the employees and their families. You say it is the option in case of, as far as we can recollect from what we have read, in case of an accidental death, it is to be done in this way. In case of another death, it is to be done in this way. In both the schemes, there is an option. you can claim either MMCC or compassionate.
Subject to certain terms and
There are slight
Yes,
deviations in
yes,
the two
slight.
conditions, but substantially this is the
You have to be under certain age, and all this needs you have to be dependent. You have to establish you are dependent. You are direct dependent, or you
direct
cannot live-
dependent has been specified,
Yes, and indirect
includes
dependent.
daughter also, and there is it is expansive definition. Just see the intention of the scheme. It is expansive that if these class of legal heirs are not available, then even son-in-law and daughter-in-law can be considered.
Your Lordship, if no such direct dependent is available for employment, brother, widowed daughter, son-in-law residing with the deceased and
Correct.
almost wholly
Subject to
dependent.
subject
Yes.
to certain
So,
conditions.
Lordship, my point is that this needs to be established through an application. It cannot, they need to make an application to state that without making an application, they become entitled to it. That in my humble submission, subject to correction, was that this is, I mean, for the ends of justice, this is.
In
this
any
ma-
of these cases, one of the applicant is beyond the direct descendant,
Lordship,
beyond the
in,
direct dependent.
Lordship, in this Maya Bauri only.
Maya Bauri, she is a daughter.
She was
She is a daughter.
Saira Khatun inside the item number 1.
Item number is
One of
that
the-
Saira Khatun is the daughter-in-law.
No, she applied for his for her son-in-law.
So she is very much alive.
No, she applied for the son-in-law.
Son-in-law she may have applied for, but she is a direct beneficiary. She will get the MMCC. You can say, I will not give it to him, I will give it to you. But you can't say, I will not give.
All our cases, the MMCC is claiming by the widow. All of them.
See, if in any case, like in that case, we have just gone through, you have sought a compassionate appointment in favor of the son-in-law.
Yes, sir.
Now, instead of compassionate appointment, if MMCC is to be given,
Yes, sir.
that will be given to you, not the son-in-law.
Yes,
Yes.
all the cases are to the widow has come.
My only point was that so much delay and without proceeding an application and making an application after so many years, that shows that maybe they are not under so much of hardship.
Just give us a compilation of the judgments. We'll keep it in the next week. We'll pass the order. We'll go through all the judgments. We have seen one or two, but we want to see any submissions you want to make. Yes.
I have filed the cross appeal for interest part.
Again, your case is determined by the earlier judgments. Your claim is also determined by the earlier judgments.
I am relying some.
So the same thing will operate against you. The coordinate bench has said,
The coordinate bench also will award the interest also.
sir, come to the judgment. Yes. Where is that portion regarding the interest?
But interest, the honorable court has the learned court has rejected. That is page 15, internal page 15, paragraph 21.
That's it. In the earlier two cases, there was no claim for interest.
Yes, my lord.
No, in Putul's case and in Sumi's case.
Yes, my lord. The Putul case and the Sumi's case, my lord, the interest, Putul case, my lord, the interest has not been, my lord, discussed by his, my lord, judgment, honorable judgment, my lord. But the, my lord, the Sumi come in respect of interest, which was not the single bench was awarded, that was upheld by Supreme Division.
Where is that? Let us see.
Well, I am relying. Single bench target.
In this judgment, while not granting interest, this delay has been taken into consideration for the
In Putul's judgment, yes.
in the impugned judgment. This one.
Yeah, sorry, in Maya Bauri judgment.
In my book.
You please see, therefore, we were going to ask you, please give us a compilation of the judgment.
Today, kindly give a
If you can give a consolidated, just mark P on which or A on the ones you are relying upon, and are on the ones, so we can.
It may be fixed, but I realize the judgment in this.
No, you give it in this week, so we can go through the judgments. Yes. Yes.
Tomorrow I think.
The learned advocates.
This my body. And that is why
Therefore, we are saying once we have considered that, then nothing will.
Then the other matter, the today supplementary list 1 and 2, and the monthly list 4.
Can you give us on a slip
Yes, yes.
with the appearance all the matters which are to come together?
Item number 7 is also.
So give it, place it on the slip. Give it on the slip.
I'm appearing, but
For the
I'm for the petitioner respondent, my lord.
All right.
The appeal I am respondent. I
Very
have
good.
applied this appeal.
Today.
7 and 9 months.
So Thursday week, it will come on 22nd, not next week.
22nd.
Compilation should be filed tomorrow.
Tomorrow, yes. All right, you can do it.
Yes,
But
yes.
Deeply. Lordship, no short written notes of arguments or anything like that. Only compilation.
what is the point in for? It's not such an elaborate thing that we need notes.
One my humble submission. One appeal prepared by my learned friends client. Today it has been mentioned before. The same fact relying on Maya Bauri, the single bench first and order, they have preferred an appeal that because
Today?
No, I'm not.
set of law here, but this time poll field.
Unless he makes a prayer, how can we list it?
They have
We are fixing all these matters for 22nd. You ask him to make a mention.
yes.
In between, if he mentions.
Mention today.
I will not be available now.
না থাকলে তো গিয়ে আমি তো করবো
আমার মাথাটা থাকে।
বলে দিলে তুমি ট্যাগ করলে
Instead of 22, 27, 8, any day one of this.
is one matter, I have 6 matter.
I have also the matter of Kamala Hela, that is the appeal they have prepared an appeal.
No, Thursday after that, 29th.
Deeply.
লিখে দাও sir.
Please give us a slip
Yes, yes.
containing all the cases so that it can all come together on that day.
Lordship, the order will be same in all of them as of
Yes.
The Cosme Devi, that was
Lordship, in one of the matters, this condonation of delay is pending. I think in Kamala Hela, this condonation of delay is pending.
On that day, we'll pass the order.
Because there was a direction for the filing affidavit and reply. They have filed affidavit in respect of my cross affidavit. May I permit to file a
In which case, let us not create
item
any.
number 6. Item number 6.
In item number 6, what are you filing?
My file reply.
Reply in item number 6.
Monthly line.
Reply is being taken on record. Item number 6 is what case number?
Maya Bauri, this is a cross.
Achha, that is okay.
Yes,
7 and 9.
What 7 and 9?
9
Oh, no.
my appeal.
Yes. He's filing supplementary. Are you also filing reply?
They have filed the appeal. I am the
How many times you will say the same thing, sir? You have said that 3 times already. Yes. Your matter is already listed along with the other matter.
Lordship, in the cross appeal, there is an affidavit in opposition. We wanted to file. Unfortunately, only one copy has come. I will file it on the next day. Some error has happened.
You will file a reply to the opposition.
To the opposition of the cross appeal of my body. We had exchanged it. Item number 6. They are cross appeal, and to that the opposition is to be filed by us. Leave.
He said he's filing a reply.
Reply I have filed.
There we had the
Oh, you have not filed it yet.
I could not find.
Place it, place it.
Lordship, only one copy is here.
No, no,
unfortunately.
give 2 copies.
Lordship,
So
that
in
is-
6, opposition and reply both are taken on record.
Lordship, can I just give it in some?
Get a copy, give it
I will
today.
just I will
Yes.
just give it in some, just a few more.
29th, yes. All these matters.
Deeply obliged.
Earlier judgment is very complex. नहीं मंथली लिस्ट नहीं कर बचा है let us go to the list. They will reply or something. Wait for it. We are requested you to give on a piece of paper. Please don't allow them to proceed. Yes. They released it too much. Yes, call the next from the supplementary, the daily list.
Original set, item number 2. I am appearing on behalf of the respondent petitioner. No.
Two is to be listed on 29th. All right. Same order. Same date, not same order, same date. List on 29th along with give the case of Maya Bauri's number.
Monthly list item number 1.
Appear for the respondent writ petitioner led by Mr. Shomu Mujumdar.
I am for the appellant. Well, on the last occasion when the matter was taken up before the another bench, my lord, we are directed to prepare one list of dates and short notes of argument. But since the matter was not, my lord, heard before this bench, so may I just proceed by oral submission. Well, by this judgment impugned before your lordship, the learned single bench, without giving an opportunity to the, my lord, the appellant hearing, that is the Food Corporation of India, to file affidavit in opposition, to bring all the relevant documents to agitate the issue as to whether any direction that which was ultimately passed before the learned single bench would have been passed or not, my lord. So a very short question is involved in this case, my lord. So before that, may I give a background of this case, my lord, because it's checkered history, my lord, right from the year 1990.
Yes. What is the date of the order under appeal?
My lord, the judgment impugned herein is passed on. My lord, we have prepared a paper book also in terms of the order previously passed. So
Where is
that
the paper
order
book?
in judgment impugned is available in paper book number, volume number 1, my lord. Page number, running page number 55. But before that, my lord, may I just give a short introduction to the background facts, my lord. That would have perhaps appealed honorable court. Me to properly agitate this. What happened, my lord, in the year 1990, the Supreme Court passed one decision whereby, my lord, the pay scale of all the workers who are working in various public sector undertakings to frame the pay scheme of pay, and the central government was given an option to appropriately frame the scheme of pay, either central government DNS allowance or industrial DNS allowance.
Where is the paper book? Yes.
Some thereof, my lord, after passing of this Supreme Court decision, my lord, the Directorate of Personnel and Employment passed one, my lord, the resolution whereby, my lord, all the employees who are working in public sector and enterprises were given an option to change their scheme of pay from central CDA to IDA, central DLS allowance to my lord, industrial DLS allowance. So whether, my lord, the Food Corporation of India is falling under that particular circular or not, so the department also agitated the issue before the appropriate, my lord, the authority of the government. And accordingly, my lord, 2011, it was made clear that the Food Corporation of India is also coming under the purview of this particular scheme. So thereafter, my lord, on 30th September 2011, my lord, that is the first circular issued by the Food Corporation of India, whereby, my lord, all the employees were given appointment, either the cutoff date was fixed at 1st of January 1989. So whether the employees were employed on that day or given the first promotion, was given an opportunity or option to convert their scheme of pay from CDA to IDA. And these give rise to several disputes. For example, my lord, once the option was exercised by all the employees, it was found that the few of the employees, or rather the senior officials who are highly ranked or ranked in the higher echelons of the hierarchy, they were getting deprived from converting from CDO to IDO because of several excess payment was found to be, my lord, recovered from them. So accordingly, my lord, a challenge was filed before the Delhi High Court, whereby that very circular which my learned friends on behalf of the writ petitioner have sought to implement was challenged. And that my lord, writ petition was filed before the Delhi High Court in the year 2011, and thereafter another writ petition was filed in the year 2012. So in close proximity, two writ petitions were filed before the Delhi High Court, wherein, my lord, this very circular which has been relied upon by the petitioner was challenged before the Delhi High Court. So by the initial order, my lord, the Delhi High Court first put an order of stay upon that particular circular because, my lord, lot of recoveries were found to be, my lord, available on the part of the Food Corporation of India. So thereafter, my lord, since the very circular was put on hold or put on stay. My lord, may I continue?
Yes, we are listening to you. The circular was put on stay.
Yes.
Implementation of the circular gave rise to a recovery from various officers. They issued their two writ petitions were filed. We are hearing you. Yes.
So, my lord, since, my lord, the very circular was put on stay, so,
Yes.
my lord, the Food Corporation filed one application for vacating the order of stay. So Delhi High Court passed an order whereby, my lord, all the orders are on record, my lord, whereby it was directed that the recovery will continue, but so far the areas amount which is found to be, my lord, payable to the employer, that will be put on. That was passed, my lord, on 22nd of February 2013. So that order is thereafter, my lord, several writ petitions filed before the petition, and at present, my lord, total 5 writ petitions are filed before the Delhi High Court. And, my lord, almost 70 or 80 stakeholders are there, my lord, and that matter is still pending. In those cases, my lord, from time to time, several interlocutory applications were filed. And all those, my lord, petitions were filed either for implementation of the circular so that the areas could have been passed or for the my lord, for the purpose of putting a stay on recovery. But all those my lord interlocutor applications so far my lord was filed were rejected by the Delhi High Court.
So all are now governed by that order that
Not only that, my lord, subsequent thereto, my lord, we also came out with another circular, whereby, my lord, we have taken a policy decision in view of that particular order that, my lord, the recovery will continue and the so far the payables are concerned that will put on hold.
where is that circular?
That those circulars are there, my lord. So I'll take another 2 minutes to just come to.
Yes. No, the earlier circular is 3911.
Absolutely, yes, my lord.
And the subsequent one?
Subsequent is, my lord, a date is, my lord.
7/12/11.
My lord, that is, my lord, 24th of May 2013.
Okay.
For the 2013.
Very well.
Now, in the meanwhile, my lord, the writ petitioner filed one writ petition before this, my lord, the Calcutta High Court, seeking implementation of the order circular, circular, so that he could, my lord, get the area salary which was found to be payable to him.
Implementation of the earlier
first one, which was, my lord, put because of the Delhi High Court.
30th September 1.
30th September 2011, my lord, yes. So, my lord, we also agitated all these issues because in the meanwhile, other petitions also filed before Punjab and Haryana court. They also took similar stand to put those cases on hold till the final disposal of the Delhi High Court. But, my lord, the learned single judge, my lord, was pleased not to, my lord, accede to our submission, and without granting an opportunity to file our written, my lord, affidavit in opposition, allowed the writ petition, whereby, my lord, the writ petition was directed, rather the Fifth Professor of India was directed to relay the areas amount. On the ground, as it finds from the order impugn, my lord, judgment and order impugn, that those orders seem personal in nature and not in rem, my lord. That was the specific finding of the learned single judge. My lord is aware of the circulars are all having a pan-Indian effect, my lord. A single circular which is issued by Food Corporation of India is having effect all the employees, which runs into several thousands, my lord. And moreover, my lord, all those petitions, my lord, which could not properly agitate because of the non-opportunity to file our affidavit in opposition, that all around 5 petitions, my lord, or around the 70 or 80 petitioners were from time to time getting added, and they have getting their conflicting claims before the Delhi High Court agitated. So far, my lord, second circular is concerned, my lord. May I bring your lordship attention to page number 120, my lord, of the paper. 120 page is not legible, so my lord, typed copy is 120 my lord. May I read, my lord?
Just give us some.
Second circular, my lord, areas were put on hold because of the Delhi High Court order was neither challenged, my lord, nor, my lord, agitated in the petition. So this second circular was never, my lord, placed before the learned single judge, so far the petition is concerned. It was neither challenged nor set aside, my lord. So still, my lord, holding.
Who has challenged the 30th September circular?
On 30th September circular, my lord, has been challenged as well as, my lord, implemented by several parties before the Delhi High Court. In total 5 petitions. And so far my instruction goes around 70 or 80, my lord, parties are there, having the conflict with claim. Somebody 80 to 90% is claiming for implementation, my lord, because they are getting benefit because of the conversion. Around 10 to 20%, my lord, among them, my lord, are getting deprived. So that is why, my lord, they are seeking quashing of the circular, my lord. And few of them, my lord, are seeking quashing only to the extent which is getting prejudicial to them. So partly quashing. That is also happening before the Punjab and Haryana High Court also. They are on one side.
That circular has been stayed.
My lord, the first circular had been initially stayed. Thereafter, subsequent orders, my lord, the order has been modified to the extent that, my lord, the recovery will continue because of the conversion. But so far the payables are concerned, like the writ petition, those will be put on hold. That was passed in the year 2013. And in view thereof, my lord, the second circular came into.
Where is the second circular? Let us.
My lord, 120, my lord. Page number 120 in the paper book, or 120A is the type copy.
One part of the Honorable Single Judge's order is as per your second circular. The order which you have assailed in the appeal, that says that recovery will be kept in abeyance. Recovery can be made if required in future.
Oh, the writ petition is seeking the release of the areas. He's not concerned about the, my lord, the recovery. His case is, since his case is for implementation, he's getting benefited because he is getting, my lord, larger benefit out of it. So he's seeking, my lord, the release of the areas. So release of areas, my lord, so far the Delhi High Court order is concerned.
So regarding release, your second circular does not say anything.
Yes, my lord.
It is only regarding recovery.
Both, my lord. Kindly comes to paragraph number 4, my lord.
Yes.
Further, in compliance with court order dated such and such, it has been decided that to safeguard the financial interest of the corporation, the recovery is to be made from the retiring employees from whom it is removable, and other cases to be kept pending till further court order. In other cases means the payable. And the order is also like this. And in pursuance thereof, several official, my lord, memorandum.
Other does not mean payable. Other means apart from petitioner, others also.
Yes, my lord.
It does not mean the payable.
Payables, my
It cannot mean payable. It cannot be read like.
Very well, my lord. In that case, my lord, kindly comes to the subsequent, my lord, OMs, my lord, that I have also attached. Kindly comes to, my lord, subsequent official memorandum that was issued in pursuance thereof, my lord. Paper book number, my lord, second volume, my lord, 208 and 209, page number. Hundred 208 is the type copy, my lord. Kindly come to the last but the one paragraph.
You are referring to 27/10/15.
Yes. That second circular has been referred to in the first line, my lord. My lord, kindly come to the next page also, my lord, subsequent poem, my lord. 09, the next page that I copy.
Yes.
So, my lord, those circulars were not kind of challenged before the land is single. That is one leg of my lord. And so far, my lord, the very
So if you comply with the Honorable Single Judge's order, which circular will be violated?
on the second one.
To what effect?
To effect, my lord,
What is the direction? Show us which direction will be violated. Which direction is in contrary to any of the circulars? Come to the judge's order.
payment of the areas, my lord. Payment of the
Let us
areas.
see, where is that?
Where is the second circular or where, my lord?
No, come to the Honorable Single Judge order.
Order.
Which order is contrary to any of these
My lord,
circulars?
my lord. My lord, come to the second page, the first paragraph says, petitioner says that there will be certain areas if the petitioner's salary practice.
We are not asking who has argued what. We are asking what is the direction. Come to page 58, third paragraph.
In the aforesaid factions, I dispose the writ petition without calling for affidavits by directing FCI to make payment of the areas.
Areas, correct. So third paragraph, page 58.
My lord.
It's not.
Yes, certainly, my lord. So area salary, my lord, which is to be found to be payable to him because he has already superannuated from the service. So this particular direction, my lord, goes against the, my lord, the second circular.
Otherwise, everything is in order.
Yes. So this is the very basis because this is the stand of the FCI, my lord, because of the
Yes.
case pending before this, my lord. And if my lord allows me, my lord, then
So
I
let us hear what they have to say. Yes.
I have certain other things also.
This 2015 circular, unless it is set aside, how can they pay the arrears?
Please come to the 15 circular.
Yes. Page 209.
08.
209, 208.
I am writing in reference to instructions issued with a circular of 2013 in the matter of shifting of employees from CDA to IDA with effect from the date of their first promotion on or after 1189. Further, by this office letter of even number dated 2015, it was reiterated that till issue of further instructions as per circular dated 24th of May 2013 be abided, and the cases of conversion from CDA to IDA pay scales be taken for all employees from whom it is recoverable to effect necessary recovery. So that's not within the courts. Till issue of further instructions as per circular of 2013 be abided, and the cases of conversion from CDA to IDA pay scales be taken for all employees from whom it is recoverable to effect necessary recovery. So this was only confined to recovery process.
Yes.
Accordingly, necessary action was to be taken immediately for compliance of the court order of 2013 in order to safeguard the financial interests of the corporation. It is requested to ensure compliance of the aforesaid orders, and all the employees at present working at present, working and drawing regular salary in the CDA scale in the corporation must be converted to IDA pay scale, and their regular salary for October 2015 onwards may be disbursed in IDA pay scale only. It is once again requested action may be taken as per FCI policy instructions issued in 2013 and 5th January 2015. That is, the recovery is to be made from where it is recoverable, and arrear, if any, payable shall be withheld pending decision of the court case.
So, my lord, the primary object of issuing this circular was to safeguard interest of FCI in the event of a recovery being made or likely to be made. The decision was to implement conversion from CDA to IDA pay pattern, otherwise even for existing employees.
Yes, but the fourth paragraph is very clear. It says neither recovery nor arrears. That has to be kept withheld.
Now, please. It is once again requested action may be taken as per FCI policy instructions dated 24th May 2013 and 5th January
13 we have already seen. It says that you will not make any recoveries.
That was only in respect at the behest of employees from whom salaries were sought to be recovered.
So therefore 13 covers the recovery aspect, not to be done. So that is reiterated. And then what else?
Yes, not this is in the context of recovery only.
Yes. And
please see from where it is recoverable.
Yes.
And arrear if any payable.
Yes.
This is confined to those employees from whom there is a possibility of recovery because of excess payment. It's not blocked to all employees. From
Recovery and arrears are two different connotations. Here they are talking about arrears. Arrear means payable. Recovery would mean recoverable.
One who has already drawn.
Yes.
From them don't recover. That's one aspect of the matter.
One aspect of it.
Arrear.
No, not one who has drawn. See what if we have understood correctly what he has briefed us in the beginning, that this conversion from CDA to IDA has in fact proved not beneficial to certain persons, resulting in recovery. So from those persons, no recovery are to be made. You implement this IDA scale, and likewise for those persons who are entitled to receive arrears, that also you don't pay, but you give them the IDA scale. So arrears, payable and recoverable are all pending decision of the High Court or any subsequent decision that
Please
may
come to the prelude of this circular once again.
Yes. Because this has to be read with the next circular,
Right, yes.
209.
In the matter of shifting of employees from CDA pay scales to IDA pay
IDA.
pattern of the third line from the top. Second line, in the matter of shifting of employees from CDA scales of pay to IDA pay scales pattern with effect from the date of their first promotion on or before 89. Further, via this office letter of even number dated 5/1/2015, it was reiterated that, not this is quote unquote, till issue of further instructions as per circular be abide of 2013 be abided, and the cases of conversion from CDA to IDA be taken for all employees from whom it is recoverable to effect necessary recovery.
Yes, yes, please proceed.
Accordingly, necessary action was to be taken immediately for compliance of the court order dated 22nd.
So this is history. This is history.
Yes.
History being recorded.
It is requested to ensure compliance of the aforesaid orders. This is the decision. Compliance of the aforesaid orders and all the employees at present working and drawing regular salary in CDA scale in the corporation must be converted to IDA pay scale. Must be converted. So the decision is complete insofar as existing employees are concerned. And their regular salary for October 2015 onwards may be disbursed in IDA pay scale only.
Only, yes.
It is once again requested action may be taken as per FCI policy instructions issued via circular of 24th May 2013 and 5/1/2015. May I just draw your lordship's kind attention to these two circulars now. The 24th May 2013 is at page
that we have read.
120 your lordships have already seen.
Yes.
And the 2015 circular of January 2015 circular is at page not annexed, of course.
209.
No, 209 is of November. Perhaps 511, instead of 511, they have written 51.
So two circulars are of
because this is a typed copy. Come to the main.
Their circulars are 23rd November and 30th November.
Oh, so this is 5/150.
Could be 5th November. It appears to from the smudged date. Shifting of employees from CDA scales to IDA pay pattern.
5/11/15.
So this is a typographical error.
No,
At page 208A.
No, in type copy 5th November 2015 is written.
Right. So at page 208, it has to be 5th November, can't be 5-1.
208 is the original. Perhaps there is a typographical error in the original itself, because it also says 0501 in the 5th line of first paragraph. 0501 2015. But the same date is mentioned in the last paragraph also.
Yes, but
0501.
document is only 5th November 2015.
There is no 0501.
Because it was explaining a circular of May 2015. It could not have been January 2015.
But how it can explain a subsequent circular?
No, that's why I'm submitting. Please come to page 209. 209 was explaining a circular of May 2015, so it had to be dated November 2015. Could not have been January.
Correct. So, no, but what we are saying is there has to be one of 0501 also, because how can 10 refer to a circular yet not in existence? On 2710, how they can refer?
This is dated 27th October. I'm sorry.
So how they can refer
Yes, has
to?
to be a January 15th.
It has
circular.
to be January. It cannot be in November. Where is the 5-1 circular?
Yes, looks like it is not.
That is important.
That is important.
As of now, what we have gathered, subject to what you all may submit
I can
subsequently,
produce one.
that the Honorable Single Judge's order, up till now, it appears to be only out of line with this 209. But what is 0501, we don't know.
Not the Delhi High Court and the Honorable Punjab and Haryana High Court cases where not the Honorable Single Judge has held that those are cases in persona, where the persons had approached for non-recovery.
See, we are, that is their grievance is, there was no opposition or report filed.
That should be a bit unfair to the Honorable Single Judge. My learned friend had appeared all along.
Okay.
He argued before the Honorable Single Judge that I want to produce these writ petitions. So the Honorable Single Judge, as your Lordship,
He has recorded, yes, that there is no point because those are decisions in person. No,
that
but
was
he,
the sole ground taken.
but he has recorded in his order that
I'm not
filing
asking for affidavit.
is not required because it is hardly relevant.
Because that was the ground taken that because of the pendency of the writ
So
petition,
therefore, let
But we
us,
did not waive
whatever
our
it is now, it is over. We have to see there are 3 circulars. If the directions are in any way conflicting with the 3 circulars, then there would be a scope for us to see whether that
examine the other.
whether that conflict is in order or it is unsustainable. If there is no conflict, then what is to be done? The order is to be
5/1/2015 has to be produced.
5/1/15 has to be seen. You will have it or you have it.
He will.
I will have it, my lord. At present, my lord, it is
You
not.
bring it.
But in my case, on the date of superannuation, that is in November 2015, they had placed me from CDA to IDA because of the Honorable Supreme Court's judgment.
Then
I said that you pay me the arrears. I am getting benefits in terms of the revised pay.
so the areas whether they could have paid and the single judge whether a direction could have been passed without setting aside the notifications or circulars issued by them, how
They were only explaining a court case. Not probably. Not if your lordship will kindly have a look at page 27. That's the 2011 circular.
But since we did not file any, my lord, rather we are not given an opportunity.
how many times, sir, you think saying the same thing again and again really helps you? Yes.
Today arguing before your lordship that we were not given opportunity would be unfair to the Honorable Single Judge. I repeat, because not my learned friend had appeared and I had also appeared.
He has appeared, he has made submissions, we have seen that, but you please see what the Honorable
Please come
Single.
to that 7 December 2011 one first.
Yes.
Shifting of employees on CDA pay pattern to IDA pay pattern with effect from the date of their first promotion after 1189. That's the genesis. Reference is invited to circular of 2011 on the above mentioned subject. Subsequent to above mentioned circular issued by the corporation on the basis of Department of Public Enterprises OM, dated 10th October to August 2009. Some officers have filed writ petition before Honorable Delhi High Court, which has been adjourned to 25/1/2012 for filing reply. The outcome of the decision of the court will affect the extent of arrears or recoveries or vice versa of the concerned employees. The matter has been examined and it has been decided that the arrears, if any, to the above mentioned class of employees will be released only after receipt of a duly notarized undertaking on a non-judicial stamp paper of appropriate value applicable.
This is of December 11. There are at least 2 circulars which have come in existence after this, 13 and 2 in 15. 3 circulars.
I just showed that please read this in conjunction, that the areas released to me in terms of the circular of 2011 shall be subject to final outcome of the repetition in so and so before the
But
deadline.
this does not hold good.
Now, please
After
come
this,
to the-
there are 3 circulars issued, one in 13 and 2 in 15, regarding what is to be done for areas and recoveries.
Now, please come to how FCI has acted at page 29.
But they must be prior to 13 and 15.
Please come to page 29. 28 is the new copy. I mean the original one.
This is whose payslip? What
My
is your payslip?
Great petitions. This is of PC. I was in the CDA pay pattern. This is for the month of November 2025.
Correct. So from October, they have paid the dues
Yes, your Lordship will be pleased to
from
find
the
that.
date of implementation.
So in November 2015, I was in CDA pay pattern. Now please come to the next page at 29.
Yes. Revised.
Revised.
Yes.
November 2015. Please come to the endorsement below that.
Yes, we have seen that from October 15.
1/1/2015 paid at rupees 32,000 3 lakhs. 32,229 with a bill of 4th December 2015.
Correct. But
So-
nothing prior to October. The issue is areas prior to October, it is governed, their cases, it is governed by the 3 circulars.
Now, not the only that one that at page 208. That is the only circular wherein they say that no areas to be paid.
No, in 209. Please see 209.
But it has come to my notice that the administrative order things so and so from CDA pay scale pay scales, and also please note that I read the next sentence. The first one is wholly. I am not venturing to read that because of the mistake that has occurred. It has come to me. Try to read it. Circulars of May 2015 and October 2015 are being referred to. It has come to my notice that in the name of want of administrative orders, the filing should be filing from CDA pay scales from November as per headquarters due letter of so to pay scale.
The shifting from.
Should be shifting from CDA to IDA pay scale, and also payment at the rate of IDA pay scale, where recoveries are to be active.
Yes.
Expected
Yes.
for the CDA pay scale employees is not being done.
Yes.
Please note that headquarters under itself is an administrative order, and no separate orders from the personnel division are required. Pay fixation on account of conversion to IDA pay scale has already been worked out, and accordingly the directions of the DO letter dated 27th October 20.
Now again, this document is not there.
27th October is
the
there.
previous page, madam.
27th October is there.
208 is the
Page
matter.
208A.
Oh, that is.
Yes, ma'am.
Oh.
Only 5/1/2015 paragraph.
So
is-
therefore, we said that this.
Documents read together will only identify cases from where recoveries are to be made.
How can you completely overlook the last paragraph of page 208?
Please come to 2091. Not 209 has to be read with 208.
Yes.
Now 209 is 5th November.
209 says it has to be worked out as per 2710.
Yes. Now
And last paragraph of 2710 deals with recoverable and arrears both. You please read the last paragraph.
But please not fifth number is a letter document. But may I read the first letter first and the letter document later?
Yes.
Now this letter at page 208 being the 27th October 2015 has to be read in its entirety. But it was only in respect of persons at present working and drawing regular pay. That is one aspect of the matter. They have to be compulsorily converted to IDA pay scale. And they are not, this was implemented insofar as this writ petitioner is concerned. He retired in November 2015. It is once again requested that action may be taken as per FCI policy with a letter of 24th May 2013 and 5/1/2015. That is, the recovery is to be made from where it is recoverable. And area, if any payable, shall be withheld.
Correct.
Pending.
So both recovery and arrears both.
Not
It
this
is
was
very clear.
not this has this was only in respect of persons, not has to be. for whom recovery is what to be made. Otherwise, that 5th November 2015 circular would not have restricted itself to those persons who were.
Therefore, it refers to 5115 also.
5115.
5115 must be dealing with arrears.
But
That is why both are referred to. 13 deals with recovery and 5115 must be dealing with arrears. That to protect the financial interest of the corporation, no arrears either paid or recovered, just give the IDA scales.
51-2015 in essence is quoted in that page 208A, not the entire one, of course. Please see, number dated 5-1, the fourth line from the top. Further, vide this office letter of even number dated 5-1-2015, it was reiterated that, quote unquote, till issue of further instructions as per circular of 2013 be abided, and the cases of conversion from CDA to IDA pay scales be taken for all employees from whom it is recoverable to effect necessary recovery.
Why repeatedly they are issuing circulars for recoverable circumstance? Because probably nowhere they were paying it. Under a fear that amount is recoverable, let us not pay. So the management is repeatedly saying, don't worry about recoverable, you pay whatever is due to them. That we will consider later when the issue is decided. In this, at the same time, in the bottom, they have said arrears. Now, arrears, can it be recovered? Can it be read as a recoverable?
They were in fact implementing by way of conversion, but for the purpose of recovery when cases had been filed in different high courts.
No, because everybody's case did not involve a recovery.
It could be on the basis of pay fixation. Now, please come to the 2013 circular. Your lordships have already gone through that.
We have gone through it, yes. We have gone.
That wanted to implement this conversion.
All these are for that purpose only.
Right. Now,
probably because the management in various offices were resisting that if we pay tomorrow, the central management will say, why do you pay without recovery? So repeatedly they are harping on, don't worry about recovery. You pay what is due under the IDS scale.
No, this conversion is not to be decided by FCA because this was done by a judgment of the Supreme Court. So this was only for purpose of implementation.
But as of today, the situation remains as it is, that there are certain orders of the court, and implementing or in purported implementation of those orders, they have issued certain circulars. Now, when the direction is issued by a writ court, either it has to set aside the relevant circular which is coming in the way of grant of that direction or relief, or after considering it has to.
The court has explained these circulars in the context of the litigation pending before you. Now, please come to the scope of the litigation before the other high courts. But those writ petitions are in the paper book. Please come to page.
Maybe. Whatever is the scope, once a circular is issued governing all the employees uniformly, how does it matter what is pending before the court?
Please, that is why in the context of those litigations, this was issued. That's why the honorable single judge has held this is in personnel.
In whatever context, the effect has to be applied uniformly. Now you come to page 58, second paragraph, just read for yourself. We have gone through it.
In the aforesaid facts and circumstances.
No, sir. Second paragraph, page 58 of the paper. Yes, allowing.
Oh, that's the first paragraph. Sorry. Allowing affidavits to be filed by FCI will not throw any further light in the matter, inasmuch as no factual statement in the instant writ petition requires to be dealt with by filing an opposition.
But there are circulars in existence.
No, that was already before the court.
No, those circulars were not before the court.
The facts are, that's the only argument advanced. That was the only argument advanced. That because of the
anyway,
orders,
that is over. Therefore, we said, when we pass the order, either we will hold that these directions are sustainable, or we will hold that it is not sustainable. So let us not commit the same. Let us see the three circulars which are in holding the field, and then we can proceed. You bring the 5-1-15 one. Most probably it is also regarding recovery, because he has right, it has been extracted. But whether that is only line or there are other paragraphs, we don't.
It was there, my lord, but in paper book somehow it has been. Anyway, my lord, I will bring. On affidavit or my lord?
Yes, something relevant.
No, not at this stage.
Okay. So you place it on record. Yes. There is reference to Not referred to in 50, not referred to in 511, referred to in 2710 15. 2710 15.
Item number 2.
APO 361.
Lord, I am appearing on behalf of the appellant, Miller.
You are for the respondent.
There are, Lord, may I say this, Lordship Miller will kindly take a look at the order dated August 29, 2025. This issue, Miller, will be clarified. August 29, 2025.
That has not been intimated to us under at least. No notice has been given to us.
So that is listed today.
Milord, both the matters are taken up, Milord.
1107 is on board today.
Yes, Milord. It is there in the list.
So you are appearing for the employer in that case.
I am sure my learned friend has received the false papers of the appeal.
Yes.
Milord, my prayer with respect to the original side matter, that is APO 46 of 2025, is that, Milord, pursuant to the earlier direction, the employee was given an opportunity to file and use an affidavit in opposition. That has been filed. That has been served to us within time. Yes.
Yes. Take it.
Milord, I would be seeking, Milord, your Lordship's humble indulgence to give me an opportunity to file and use an affidavit in reply to that affidavit in opposition. Any short
You are
date would be
filing it in which case? And what is the note regarding determination that you were referring to?
Group 3 appeal because they are the employee going before the Labour Commission and Labour Commission refused to give any leave. Thereafter, challenging that order, file an application before the people just having the group 3 determination. Therefore, my objection is we are concerned does not confer the therefore,
Jurisdiction on which court?
for the group 6 court and matter appeal to group 6 court and thereafter justice our acting chief justice CJP justice Peter Das they was pleased to die on 26th August 2025 to file a report while trying to see the order. Whereas this order has not been
There is an order which I showed your lordship. Because there is a larger issue involved, your lordship has seen the order of 29th August.
And it has already been decided by the other coordinate division bench, my lord. And they file the cross appeal and they file the review.
Is there any report pursuant to this order? Is there any report pursuant to this order? कैसे पाएगा वो? How to get it? No, if there's a direction, it has to be complied. We don't know.
As falls from your lordship.
No, as already directed.
Yes, but there is also an order of 29th August 2025.
Sir,
Yes.
the two orders are in two different
Understand.
cases. It's not in one in the same order.
I understand.
You know that very well. Yes.
But it is, my lord, in the original side matter where the Honorable
Maybe.
Chief Justice was of the
Maybe. Is there any dispute that both have to be heard together?
No, there is no dispute.
Then therefore, it's very crystal clear what is to be done. We must see the report at least.
Yes.
Issue has been decided by the other coordinate bench sitting.
That comes later. You can't blow hot and cold at the same time, please. Yes. We got an order in this. To this matter, is it listed with that FMA?
We put on that.
As FMA is on the list. Which number? FMA. APO, FMA is not there. There is only FMA one for this. नहीं वो तो आना ही है. It should come. Yes, take down. There is an order of 26/8/25. We have given 2 weeks, let it come back, then we'll decide.
Because there was no direction actually, but that's why I was making this.
So let it come back, see if there is a lack of jurisdiction, then whether you have filed appeal this side or that side, that hardly matters.
Very good.
Yes. And if there is no lack of jurisdiction, then also it hardly matters. Yes.
Item number 3.
Hearing for the respondent, petitioner lordship.
Not today.
Item number 8.
Matter appear for the appellant. GA number 1 is, my lord, condonation of delay, my lord, and the GA number is stay application. I am, my lord, seeking your lordship's leave to rely on, my lord, supplementary affidavit with regard to GA number 1.
You have filed a cross application. It is not on board today. Give the number.
The number is 12.
That is affidavit of service.
No, my lord, this is my lord supplementary affidavit with regard to the GA number one, my lord, condemnation. I have explained the delay, my lord.
OGOT 1 of 2025.
OT
OCOT.
1 of 2025.
What do you want to file?
My lord, this is supplementary affidavit upon service, my lord.
Why?
Because my lord, condemnation of delay application is there, my lord, GA number one. I have explained the delay, some developments made after that, my lord. We could not make that at the time of.
So this is supplementary in GA.
GA1, my lord. There is two GA, my lord, GA1 and GA2, my lord, with regard to GA1.
Are there respondents other than the persons who have filed the cross appeal?
No. We have served.
Let us see the file. You are for which respondents?
Respondent number, we are for the repetition.
Respondent number 4. 4. 1. And who are 2, 3 and 4? 2, 3 and 4 are pro forma respondents.
Bank office.
So you are the contesting respondent. Serve a copy.
Malaya, sir. May I file one?
Yes.
I will serve one.
The
Item number 10.
Item number 10, I am the applicant. Item number 11, Mr. Ghosh is the applicant. I am seeking time, my lord. I was not well, my lord. I could not prepare myself, my lord, for 1 week time. 10 and 11.
1 week change.
an adjournment is sought for
Well, only
by
one
the
thing.
learned.
Well, only one thing, my lord. My client has died